Hey there, everyone. We're going to talk today about DUIs, also known as DWIs in some states. We'll talk about what it means for a police officer to pull you over under reasonable suspicion that you've been driving while under the influence of alcohol or drugs, what tests are administered at the scene, such as the recite the alphabet test, touch your nose test, the horizontal nystagmus test, and many of the other tests that you may or may not be familiar with. We'll talk about which of those tests actually have scientific validity and which are just tests that really don't measure anything. And we'll talk a bit about how the law works in the state in which I live and practice, California. And to that end, we will have an interview with Omid Haghighat, who is a public defender in Los Angeles. He is a criminal defense attorney who specializes in these types of cases. And he'll talk about what it means to be pulled over for a DUI, what rights the officer has to initiate an investigation, which of these tests are scientifically valid and which just simply aren't, and some other things relating specifically to California DUI law. But many of this may be similar to the protocols in other states, for instance, the use of a breath test, also known by its trademark name, the Breathalyzer, how that's measured, how it can actually tell whether someone is impaired or not, how the right to remain silent works under these circumstances when you're pulled over for a suspected DUI or DWI. We'll talk a bit about marijuana DUIs, which is a growing and emerging field now, and much more. Just a quick disclaimer before we start. None of this should be taken as legal advice. While we do believe at the Legal Seagull that there are certain circumstances where you may consider representing yourself, a DUI and other criminal cases are not that type of situation. We do recommend that if you are charged with a DUI, DWI, that you hire an attorney for that purpose and only represent yourself if you absolutely cannot afford an attorney and have no other options. So again, this is not legal advice, and what we talk about pertains specifically to California law, but it may be similar or be very different than the laws in your jurisdiction. Now we're going to move on to the interview portion with my good friend Omid. This was originally done as part of a Legal Seagull podcast, so there's no video footage. Instead, I asked the editor to take our voices and create cartoons out of them. The cartoons don't exactly look like us, but one thing I do appreciate the editor doing is making my cartoon about 60 to 70 pounds lighter than I am. So without further delay, here's the interview. Omid, welcome to the show.
Hey, glad to be here.
What are the different types of DUIs? We all know about the 0.08% blood alcohol content level. A lot of people tend to think that that's pretty much the prime ingredient in most DUI convictions. What are the different types?
Well, in any alcohol DUI charge, basically you're dealing with two charges. You're dealing with one that says that you were driving and you had a blood alcohol level of over 0.08. You have another charge that says you were driving and you were too impaired by either drugs or alcohol or a combination of both to drive safely. It's a little more complicated than that, but those are essentially the two types of charges. Let's assume that we're just talking about alcohol right now. And let's say someone's driving, they get pulled over, they do a breath test ultimately, and they have a 0.14 blood alcohol level, according to the breath test machine. They can be charged with both driving with over a 0.08 and being too impaired by alcohol to drive safely. If we're talking about your blood alcohol level, we're talking about having tested it with either a breath test machine or a blood test. So insofar as you're using some scientific method to test your blood alcohol level, those are scientific. When it comes to being too impaired, or rather driving under the influence without the requirement of a blood alcohol level, there are a number of tests that officers use that are not testing your blood or your breath, but in fact are testing your ability to do certain field sobriety tests or otherwise. This is all regulated by the National Highway Traffic Safety Administration, and some of the tests that they have designed are said to be scientifically validated. So insofar as those tests are done correctly and are scientifically validated, many prosecutors and officers will say that those are scientific tests as well.
So we're going to get into this whole area of the field sobriety tests, which is one of the things that most people know about, the whole touch your nose, recite the alphabet backwards, try and walk in a straight line. We'll get to that, but it sounds like there might be some dispute over whether these tests are all valid or that they successfully measure impairment. But let's walk through the entire process. Let's start with the time when someone's driving a car, they've left a bar or their home, wherever it is that they've been having a good time, and they get pulled over. Now, there's one of two ways this could happen. One is that they get pulled over the way everyone is probably used to getting pulled over, and then there's the DUI stop. So why don't we start with that? Take us through it. What happens at that point?
Well, I just want to add that sometimes it's not that they're pulled over, but sometimes they get into a car accident. And then when the police officers arrive and do a little investigation, they start to realize that maybe one of the individuals in that car was under the influence. So that's another way that someone can be, well, essentially someone can have an officer initiate a DUI investigation.
So let's start first with the whole DUI stop, the type that many of us in LA are used to, where you're driving and all of a sudden you see a sign that there's a sobriety checkpoint. What are your rights essentially when you see a sobriety checkpoint ahead? Is it illegal to turn your vehicle around to try to avoid it? I'm not suggesting that anyone should do that, but only to see what are the rights that are available to you as of the time that happens.
Well, as far as I know, a DUI checkpoint isn't like a black hole. If you come within the vicinity, you aren't required to be sucked into its oblivion. If you do turn around, however, an officer can see that, and oftentimes they do have officers in the outskirts of those checkpoints looking for people who are turning around. And if the officers do see you turning around, that can raise their suspicions, and they can attempt to pursue you and see if you commit a vehicle code violation and then pull you over and initiate a DUI investigation. Otherwise, if you drive into the DUI stop, you're there and you have to comply with the officer's requirements.
Now, once you're either pulled over or you come to a DUI checkpoint or it's an accident, there comes a point when the police officer suspects you've been drinking, or at least claims to have suspected that you were drinking. What types of questions are they allowed to ask at that point in the investigation?
Well, an officer can ask you anything. This is assuming that you've come into a legal checkpoint or if you've legally been pulled over. An officer can ask you anything, and the kind of questions they'll ask is, where are you coming from? Or have you had anything to drink tonight? The where are you coming from is kind of a question meant to see if you're coming from a bar, and that'll make them suspicious. But essentially, they'll ask these questions of anyone if they're slightly suspicious of a DUI, but they don't really begin to trigger their DUI investigation, I think, until they see what I consider the holy trinity of objective symptoms of drinking.
And what's the holy trinity?
So I call it the holy trinity. They'll put this in the report. They either smelled an alcoholic beverage on your breath, they'll notice that you had bloodshot, red, watery eyes, or that you had slurred speech in responding to any of their questions.
I have read, without exaggerating, about 5,000 to 10,000 police reports in my career thus far. I strongly believe that there must be some bank that they draw these from or that they're copy-pasted, because I cannot tell you how many times I've seen this described the exact same way. I detected a strong odor of alcohol emanating from his person. Do you have any idea how this happens, that all these police officers tend to describe this in the exact same way?
I have some opinions. I've seen this happen, and I think there are two reasons for it. You're never going to see a police report without these three things, because no officer is going to do a DUI investigation over someone that doesn't seem like they've been drinking alcohol. So you'll never see that police report. But on the other token, officers need to justify the DUI investigation. Otherwise, the results of their DUI investigation can be suppressed in what is called a suppression motion. It's a Fourth Amendment violation motion, because they can be said to have had no reasons to prolong what should have been a routine traffic stop and initiate a DUI investigation. So it depends on how cynical you are, really.
This gets us to one of the main points here. So a police officer needs probable cause, is it, or a reasonable suspicion of alcoholic impairment before they resume with any type of investigation or asking you to submit to testing?
If a police officer pulls you over, all he needs is some reasonable suspicion to pull you over, that you committed some vehicle code violation, or that you might be under the influence. And let's just talk about that. What does it take to be pulled over? Some people get pulled over for very obvious under the influence reasons. They're straddling lanes. Maybe they're in between two lanes. Maybe they're swerving within their own lane. Maybe they're drifting into another lane. Some of them are speeding, or maybe some of them are just driving erratically. People can be stopped for other reasons. I've had many DUI cases where someone was stopped because they had no seatbelt. They had an expired registration. Their tail light was out. I even had an individual pulled over because his trailer hitch covered a tiny portion of his license plate number. So once they get pulled over, all that's required is reasonable suspicion. And if the officer approaches the vehicle and he smells the alcoholic breath, sees red, watery eyes, and he hears slurred speech, that can be enough for him to have further reasonable suspicion that you may be under the influence. And he can initiate a DUI investigation. They have that right. Now, they don't necessarily need probable cause until they arrest you. And you're not technically arrested, according to the police, until the end of a DUI investigation. So while they do need probable cause to arrest you and take you to the station, the entire process, including the field sobriety test, the questions that they ask you, and even the preliminary alcohol screening breath test that they give you on the field, that's all part of them establishing whether or not they have probable cause to arrest you and take you to the station.
One of our past episodes of the Legal Seagull, episode 2, You Have the Right to Remain Silent, was about Fifth Amendment rights, the right to avoid self-incrimination by not speaking to the police under many circumstances. Do you have the right, at the time you're pulled over, to refuse to talk to a police officer?
Absolutely. You obviously don't kind of want to be a jerk about it because you're not going to help your case. No one got out of a traffic stop, whether or not it's DUI or just getting pulled over for a ticket, by being a jerk to the police officer. I can tell you that for sure. But you're very much within your rights to say, "Excuse me, officer, if you don't mind, I'm going to decline to answer any of your questions." And if the officer thinks that you smell like alcohol or that you've got slurred speech, then he can still initiate his investigation, despite you saying anything. You can remain silent, but that doesn't mean that he can't continue his DUI investigation.
Even if you don't smell like alcohol, though, and you were to say to the police officer when he or she asks where you're coming from, you say, "Officer, I'm exercising my Fifth Amendment rights not to incriminate myself." Couldn't the mere refusal to answer a simple question like that be the basis for an officer's reasonable suspicion that you must have been drinking?
Not in court. So if an officer puts in his police report that he pulled someone over because they weren't wearing their seatbelt, it was late at night, so he asked them, "Have you had any drinks?" And then the individual responded that, "Officer, I'm not going to answer those questions. I don't want to incriminate myself." And without the other facts, the Holy Trinity, if you will, the breath, the slurred speech, the bloodshot eyes, if he was to initiate a DUI investigation and take you back to the police station, and let's say he takes your blood and you have like a 0.15 blood alcohol level, very likely in court that wouldn't stand up because essentially he had no reason, he had no articulable facts to believe that you were under the influence of alcohol. And he can't use your Fifth Amendment right to remain silent as reason that you're guilty.
The most popular question that's asked is, "Have you been drinking tonight?" To which it seems like everyone always responds, "I had 2 beers with dinner, officer." At that point, what happens next?
Well, it really depends. Look, the officer has a great deal of authority in that moment. A lot of the better trained officers can kind of look into your objective symptoms just by standing right in front of you and decide, you know what, I don't think this person is under the influence of alcohol, and they can let you go. What we can assume for your hypothetical is that the officer is absolutely hell-bent on doing a DUI investigation on you and whether or not he's allowed to based on that. So if you do admit that you've had drinks, even absent the objective symptoms, that may be enough for him to initiate his DUI investigation.
Now let's talk about these field sobriety tests as we discussed earlier. What is the state of the legality of these types of tests and their admissibility into court in California? I imagine that this might be similar in other states, but as you answer this, I'm aware, and the audience should be aware, that you're speaking about California law.
Well, they're certainly legal. These are tools in the officer's tool belt with which for them to decide whether or not you may be under the influence of either alcohol or drugs or both. So it's all for developing probable cause that you're under the influence. So they're absolutely legal, and it really depends on who you ask whether or not they are useful.
Can they be refused?
So that's a good question. An officer will never tell you that these tests are voluntary. However, you may absolutely refuse them in California without any consequence. But just know that if you refuse those field sobriety tests and the officer does believe that you might be under the influence, you're pretty much asking for a trip to the police station.
Let's assume for purposes of this discussion that in the first scenario, you agree to do these field sobriety tests. What are the different types of tests, and what is their reliability or scientific basis, if you will?
Okay, so there's this entity called the National Highway Traffic Safety Administration. They essentially are the ones who are behind a lot of the rules and regulations and a lot of the uniform field sobriety tests that happen around the nation, amongst other things. They have spent lots of money, and there has been lots of money poured into them to scientifically validate certain studies. So while there may be many field sobriety tests that people talk about, there's actually only 3 scientifically valid field sobriety tests. The first one is a mouthful. It's called the horizontal gaze nystagmus test. It's essentially a test, without getting into too great of detail, where the officer is testing to see if you're under the influence by looking at the behavior of your eyes as they track a stimulus, sometimes a pen light, sometimes just a pen, that the officer is holding out in front of your face. What the officer will essentially do is he'll instruct you to stand up straight, put your arms at your side. He'll hold the stimulus about 12 to 15 inches from the bridge of your nose, and he'll move it from left to right. He'll essentially be looking for nystagmus, which is a jerking motion in your eyes. There's a couple clues that the officers actually look for. In fact, there's 6 clues that they look for. The science has shown that this is actually, if done properly, one of the best field sobriety tests for predicting whether or not someone is under the influence. And there's actually scientific studies which lawyers are often trying to keep out of court that say that if it's done properly, you may even be able to assign a blood alcohol level to certain results of this horizontal gaze nystagmus test. The problem arises, however, because a lot of officers don't know how to do it correctly. It requires precision. It requires precision with how far the instrument is held from your face, how far to the side you hold the stimulus, and so on and so forth. So one thing that is ripe for cross-examination in trial is whether or not the officer conducted the test properly. The science is clear. If they do not conduct the test properly, then the results are drawn into question. The next test is the walk and turn. And the officer has no obligation to give you these tests in any order. But the walk and turn is probably the most commonly known field sobriety test. The walk and turn test, the officer instructs you to stand with your feet one in front of the other, touching heel to toe. Keep your arms at your side. And then they tell you to count 9 steps, tell you to do a turn, and they instruct you on how to do the turn, and then to walk 9 steps back. And they're also looking for a number of clues. Those clues include whether or not you actually were able to touch your heel to toe on every step, whether or not you actually kept your arms at your side, whether or not you stumbled, or whether or not you were falling from side to side, how you performed the turn, and in general, whether or not you were able to listen to the instructions. The point of these field sobriety tests is that they're simulated divided attention tasks. The idea is that driving is a divided attention task. You're looking forward while you're pressing the gas, while you're also focusing on traffic around you and trying to look at where you're going.
Texting.
And texting, yes. Of course, we're joking. But yes, and also looking in the mirror and doing your makeup, which is something that I do often. The idea is that mental impairment, when you're under the influence, begins to manifest before physical impairment. And these tests are divided attention tasks that measure both mental impairment and physical impairment. So in the case of the walk and turn, they're essentially seeing, can you follow instructions and do as the officer told you, mental impairment, but also be able to maintain a straight line and turn without falling over yourself, physical impairment. So the final scientifically validated test is the one-leg stand. I think this test is really unfair. Because I think depending on your physical fitness level, depending on whether or not you've had any injuries, this test could be very difficult to perform even for a sober person. Essentially, one leg stand is you're asked to stand with your feet together, your hands at your side, and you're asked to lift your leg up at least 6 inches and point your toe forward. And some officers will ask you to count to 10. Some officers will ask you to count to 20. And if they instruct you, if you put your foot down, to just lift it back up and resume counting. And then after that's done, they'll ask you to do it with your other foot. The idea is that they're looking to see, can you follow instructions? Are you using your hands despite the officer instructing you not to? Are you swaying from side to side? Are you able to count while holding your leg up and pointing your toe forward? A divided attention task. And there's a number of clues. And those clues have to be marked down and noted properly, because that's the only way that this test has been scientifically validated. So those are the 3 scientifically validated tests. And again, there's many things that can make these tests unuseful in a court of law or for the officer. For example, if the test is not done in the right circumstances, if it's not done on level pavement. I've had a case where the officer had my client do a field sobriety test on a hill. Of course, he didn't write that in his police report, but when he wrote the location of where he did the test, I looked it up on Google Maps and I saw that it was a hill, and I showed him on the stand. I was like, "Isn't this a hill?" And needless to say, that officer was a little red in the face, because it was a hill, and that absolutely affects your ability to do these tests properly. In addition, whether or not you've had an injury can affect whether or not you do these tests properly and whether or not the results are actually valid, especially if you've had a head injury, like in the example of getting in a car accident. Obviously, if there's a car accident and there's a suspicion of drunk driving, the field sobriety tests are done. And that head injury can cause you to fail all the tests, even if you are sober. So if the officer does these tests correctly and in the correct circumstances, then what the National Highway Traffic Safety Administration says is that these 3 tests are scientifically validated to show if someone is too impaired by either a drug or alcohol. These are tools that the officer uses to form an opinion. Now, if the officer can say, or an expert can say, that they're scientifically validated, that just helps the jury consider the officer's opinion with respect to those tests. It doesn't change whether or not they're allowed to be heard in court. So with that said, it doesn't need to be a scientific test to inform an officer's opinion. But if it's not a scientific test, then defense attorneys oftentimes will use that to say, well, if this test isn't scientific, why are we using it to convict a man of a crime?
So where does this leave the other tests? Like, what about the recite the alphabet backwards test? Any scientific validity for that?
Absolutely not. I think that's one of the most unfair tests you can have, because some people don't even know the alphabet. No, but seriously, it's a difficult test for a sober person to do. Try it right now. Try to recite the alphabet backwards. You'll probably do it slowly, and the officer will probably be able to write things that make you look like you're doing it slowly, and then say in court that you were probably under the influence of a drug or alcohol. There's another test that's actually commonly used. It's called the Romberg test. You stand with your feet together, hands at your side, and you close your eyes and you tilt your head back and count to 30. What the officer will tell you is that you want to estimate 30 and then tell the officer when you believe you've reached 30. And the officer has a stopwatch right there, and he's also finding out what 30 seconds actually is. And the idea is, depending on what your jurisdiction is or what the officer is using in his consideration, if you complete the test at plus or minus 5 seconds of 30 seconds, sometimes some officers believe 10 seconds of 30 seconds, then you're within an acceptable range. But if you, for example, tell the officer, okay, 45 seconds has gone by, but really you think it's 30, probably you're under the influence of some depressant. However, if you're on, for example, a stimulant, like if you've done lots of cocaine and then you get pulled over, you'll probably count 5 seconds and then you'll be like, yep, that was 30 seconds. And the officer will just look at you funny. He'll be like, this guy's probably under the influence of a stimulant. So the test can help inform them while they're not scientifically validated. The test can help inform them of the type of drug that they're on, even if it doesn't mean that they're scientifically validated.
What about the touch your nose and stick your tongue out, or however it is?
The touch your nose is commonly used. It's absolutely commonly used. It's another divided attention task because you're switching arm to arm and attempting to touch your nose with your eyes closed and your head tilted back. Again, if it's not scientifically validated, it doesn't mean the officer can't use it to form his opinion. It doesn't mean the officer can't testify it in trial. It's just a matter of what weight that the jury gives it at the end of its determination.
Now on to the breathalyzer test at the scene of the traffic stop. I know if you're under 21, you have no right to refuse a breathalyzer at the scene of the traffic stop. Are there any other circumstances where you can refuse to take one?
I can speak for California. And in California, unless you're on DUI probation, you don't have to do the preliminary alcohol screening device breath test at the scene of the incident, whether it's being pulled over or a car accident. The officer, in fact, has to admonish you that the test is voluntary, whereas, as I said before, they don't admonish this for the field sobriety test. Now, understanding that, if you don't do the preliminary alcohol screening device, the officer is likely going to take you to the police station and ask you to do one of the required by law, at least in California, breath or blood tests. So it's completely up to you whether or not you want to do it. Some people make that choice. Some people choose otherwise. Now, the preliminary alcohol screening device is probably the size, depending on the actual device, a little bigger than your fist, maybe a little bigger with its battery pack than that. And the officer has it in his vehicle. It's considered a field sobriety test by officers, meaning that it's not considered a chemical test. However, the technology that it employs to determine your blood alcohol level is the same as the machine at the station, which is much bigger, much heavier, and a little more technical. The idea behind a breath test is actually kind of interesting because the idea is you're breathing into a machine and it's determining how much alcohol you have in your blood. And without getting too detailed into the science of it, essentially, these little sacs, alveolar sacs in your lung can emit some level of alcohol from your bloodstream. There's a partition ratio, essentially a ratio of the amount of alcohol that's emitted into your lungs compared to how much alcohol that means you actually have in your blood that scientists have come to. And essentially what happens is when you breathe into the machine, that tiny amount of alcohol that's in your deep lung air gets multiplied by sometimes the number is 2100. And that's how they determine how much alcohol is in your blood. So that's essentially the idea of the machines.
Can the standard, I keep calling it a breathalyzer. I think that might be the trademark term for it.
Well, the one that they use in the field is called the preliminary alcohol screening device. Just like a cellular phone, there are different brands that different law enforcement agencies use. However, the smaller, tinier one is the one used in the field.
Can that device also detect marijuana or other drugs or just alcohol?
No, those devices essentially, what they're designed to do is they're designed to test ethyl alcohol. That's a chemical in alcohol. And what happens is when you breathe into these machines, there's a fuel cell inside of the machine, and it responds to a number of chemicals, one of which is ethyl alcohol. And it creates a charge, and the strength of that charge then indicates through a complicated algorithm what your blood alcohol level is.
I've been hearing about field tests now that are done to detect marijuana. Do you have any idea how those work?
Yes, essentially what they do is they have a bag of Funyuns and they hold it in front of you. And if you cannot resist the Funyuns, then they have determined that you are under the influence of marijuana. But actually, it's not like that at all. This is a brand new approach. Certain law enforcement agencies are testing it out. There has been to date no way to test whether or not someone has marijuana in their system in the field. They're employing this swab. And essentially what they do is they swab your cheek and they test the cheek cells and they determine whether or not you may have marijuana in your system. Wow. Not a lot of law enforcement agencies use this. And as of now, it's nothing more than a tool for determining probable cause, whether or not you might be under the influence of marijuana. The ultimate tool is the blood test, sometimes the urine test.
Before today, you had told me some really interesting things about the marijuana test, how it might be a little bit less than scientific in determining impairment.
Yes, absolutely. So the marijuana test is a very frustrating test for me as a criminal defense attorney. It essentially can't show a lot depending on the test results, other than that this is a chronic smoker who may or may not be high at the time of being tested. When your blood is tested for marijuana, it's tested for two things. It's tested for an active THC ingredient and an inactive THC ingredient. Essentially, it's called carboxy THC. It's a metabolite. The metabolite is like ashes to the fire. It can show that you have smoked maybe as recently as that same day or as 2 or 3 weeks prior. And it's a number that's measured in nanograms per milliliter. And certain law enforcement agencies will look at that in determining whether or not someone might have been under the influence of marijuana. And then there's the active ingredient. Now, the active ingredient, most laboratories will only test the number of that active ingredient from 2 to 25 nanograms per milliliter. And that active ingredient can show potentially if you have marijuana in your system, but not that you're under the influence of marijuana. And I want to make that distinction clear, because just like alcohol, you can have alcohol in your system, but not be too impaired to drive, which is essentially the legal standard in California. Well, what that means is there is no way to look right now, according to the scientific evidence, to look at the amount of active THC in your blood and determine that you were too high to drive, essentially. And what that means, again, for people who are chronic smokers can be pretty bad. Let me give you some scenarios. Let's say you're a medical marijuana patient, which is legal in California, and you smoke marijuana every day. Let's say you smoke on Wednesday night to go to sleep because you needed to go to sleep. And you wake up the next day, you feel fine, and you drive to the store. And for some reason, you're pulled over. And maybe because you've had marijuana in your car from purchasing it from the dispensary, your car smells like marijuana. And the officer says, "Have you had anything to smoke?" And you say no. And let's say the officer sees some other things that he thinks might be indicative of you being under the influence of marijuana. Understand that this hypothetical, you're not under the influence of marijuana. The last time you smoked was the night before. He can take you to the station, he can do a blood test. And essentially what can happen for a chronic smoker is a very high result of the marijuana metabolite, the inactive ingredient, and a tiny yet measurable active THC in your system. And the reason for that is that if you're a chronic smoker, the scientific studies have shown that chronic smokers can have a tiny amount of active THC in their blood constantly because it kind of hides in their little fat cells and is constantly being released. You may be charged with driving under the influence, and you may have to go to trial in order to prove your innocence because you're a chronic smoker. And that's just the state of marijuana science right now when it comes to driving under the influence. There is no per se limit in California. However, other states do have a per se limit. I know Colorado does. I know Nevada does. In fact, Nevada has one of the scariest per se limits, and I'll explain why. Because they have a per se limit for the active THC, but they also have a per se limit for the inactive THC. And what that means is if you are a chronic smoker and you smoke on Wednesday night, and then on Thursday you don't smoke, and then on Friday you drive from California, where you were legally allowed to smoke, to Las Vegas. If you are pulled over and the officer suspects that you may be under the influence of marijuana, even though you are not, he can make you do a blood test and you can be charged and convicted with a marijuana DUI because of the inactive THC that has been in your system from the marijuana you had been smoking even up to weeks prior. It's a scary thought.
What is the deal with people who are chronic pain patients, either cancer or any other disease, and they have a prescription for narcotic pain medications like oxycodone, Norco, Dilaudid, very powerful narcotics that in some ways impair your ability to drive, although some people would argue that they're fine?
Well, California is clear, and I'd imagine this be the case in the rest of the nation. Just because you have a prescription to take a certain medication, that doesn't mean you have an absolute defense to driving under the influence of that drug. In fact, many of these medications are very clear: do not operate heavy machinery or drive.
Let's assume that all this has happened already. You've been pulled over, talked with the police officer, done the field sobriety test, the breath test, and the officer has decided not to let you go, decided it's time to take you to the police station. What happens when you get there? What else can they do to you there, and what are your rights in the police station?
If the officer determines that there is probable cause to believe that you're under the influence of a drug or alcohol, he can take you to the police station. And essentially, you now have a choice. The officer gives you a choice. You need to provide a chemical sample. That could be in the form of a breath test, or if you like, you can do a blood test. If they suspect you of drugs and alcohol or just drugs, they very likely will require you to do a blood test.
Is there a difference one way or the other over the accuracy or how quickly it'll show up in your blood versus your saliva or urine?
No, the idea behind the breath test is that it is measuring the current blood alcohol content. The only real advantage to taking the blood test, well, one of the main real advantages, is that you can retest that blood at a later date if the law enforcement agency saves a sample of that blood. And in California, they are required to do so at your request. And oftentimes many police stations will do so automatically. And this matters because essentially, imagine what's happening. They're taking your blood. And oftentimes what they'll do is they'll put a preservative in your blood to make sure that the blood alcohol level doesn't diminish. So they'll put the preservative in your blood and then they'll test it at a laboratory. And in fact, in Orange County, a lot of DUI convictions had to be overturned because they found that the laboratory that was testing blood for alcohol was doing so incorrectly and with incorrect measurements by mistake. You're really trusting this law enforcement laboratory to tell you if you're under the influence of alcohol. So it's great to be able to have an independent laboratory test your blood and test if there's any irregularities that might show that this blood alcohol level is, for example, an anomaly. The flip side is if you take the blood test, you're spending the night at the station because they can't determine whether or not you are too impaired or your blood alcohol level in general right away. So you have to stay the night if that's okay with you. I'm sure it's not. The breath test is a really simple test. You essentially blow into it twice. And the reason you have to blow into it twice is, I may have explained it before, is that they need to ensure that the result is not an anomaly. Actually, in California, there are special regulations as to how the breath test needs to be administered and how the machine needs to be maintained and calibrated. And the reason that it's required for them to give you two tests is, well, let's say there is some particle in your breath. Let's say there's some spit, or maybe you have a cavity that's been holding some of that alcohol you drank an hour before. The reason there can be an anomaly in a chemical breath test is because you may have some alcohol in your spit. You may, in fact, have some reflux disorder that causes alcohol from your stomach to come up through your throat and then enter the machine and essentially give too high of a reading, a falsely high reading. So you have to blow twice and you have to wait 2 minutes in between each blow. And in California, if the results are more than 0.02 points away from each other, then that test is said to be essentially invalid.
Do you have a right to refuse a chemical test or a blood test, at least in California?
This is the point at which you start to have no choice. Before, you didn't have to answer the officer's questions. You didn't have to do the field sobriety test, and you didn't even have to do the preliminary alcohol screening device. But once you're at the station, the officer asks you, do you want to give a blood or breath test? And in California, and I'm sure many other jurisdictions, if you refuse to give that test, that results in an automatic 1-year suspension of your driver's license. So you essentially don't have a choice. And in fact, in California, if you're charged with a DUI and they found that you did willfully refuse, they can essentially not only, obviously, they've already suspended your license, you can have a mandatory jail enhancement as well. In order to refuse, it's actually quite interesting. They have to fully advise you of your rights before you can be said to have refused. So they have to tell you that you have a choice between a blood or a breath test, unless they suspect drugs and you only have a choice of a blood test. They have to tell you that you don't have a right to an attorney at this point, and that if you don't submit to the test, it can be used against you in court. They have to tell you that not submitting yourself to the test can result in a mandatory fine or imprisonment. And they have to tell you that not submitting to a test can result in a 1-year license suspension. Now, this is just in California, but the idea of fully advising someone of their rights to refuse is, I think, nationwide. If you are not advised of all these things, then you can't be said to have willfully refused because you were not fully advised, and the consequences may not come down on you. But that all depends.
Let's assume you've had your breathalyzer test, spoken with the police officer, maybe even had some field sobriety tests, and the police officer has determined that there's a good reason to bring you down to the police station to do further testing. What is the evidence that can be used against you in court?
In court, if you truly believe that either you are not too impaired to drive, or that you don't think the state of the evidence should be able to convict you of such a crime, and you decide to take this to trial, essentially you have 2 hurdles in California to overcome. Like I said before, there are 2 charges for every DUI that includes a blood alcohol level. There's, were you driving under the influence, or were you driving with a blood alcohol level of 0.08 or higher? For the purposes of the jury, under the influence doesn't mean I could feel the effects of the alcohol. It actually has a very specific legal definition. In California, the definition is that a person is under the influence if, as a result of drinking an alcoholic beverage or taking a drug or both, his or her mental or physical abilities are so impaired that he or she is no longer able to drive a vehicle with the caution of a sober person using ordinary care under similar circumstances. So essentially, that's the standard that the jury has to decide whether or not you're too impaired. At court, all the evidence that we talked about today is going to be used against you. Every single piece, from the reason you were pulled over to the smell of alcoholic beverage on your breath, slurred speech, and the bloodshot eyes, to the results of the field sobriety test, and the preliminary alcohol screening test, and finally, the results of your breath and or blood test. Now, it's important to note, and this has happened to me and my colleagues often, you only need to be convicted at a jury trial of one of those to be convicted of a DUI. And so what that means is you can give a blood test and it could come back with your blood alcohol level being 0.15, but for some reason your tolerance is such that you're able to be 0.15 and not be a danger to society or to the community because you're able to drive so safely and your brain is able to operate so well. And if that's the case, you can still be convicted of the DUI because your blood alcohol level was over 0.08, even though the jury finds that you're innocent of driving under the influence. It's wild, and it does happen. Jurors do come back with that verdict. And unfortunately, you still get convicted. And the reason for that is because I think that the scientific evidence is important. The blood alcohol level is important because a lot of what is being used to prove that you're driving under the influence, as opposed to driving with over 0.08 or over, is subjective to the officer doing the tests. And while the officers will never admit on the stand that they're being subjective, they really are. Every officer performs these tests differently. Every officer has a different idea of what these tests are showing. And so it can be quite abstract for a juror to wrap their head around when they're listening to an officer spout off all the different clues that were exhibited in the horizontal gaze nystagmus test. Throughout many of my trials, the moment the word horizontal gaze nystagmus test is uttered, at least one person starts to fall asleep, if not more. So it's not only difficult for them to grasp, it's also very boring stuff. So that's why a lot of jurors will hang their hats on the 0.08 or higher. With that said, at every stage, there's a way to discuss potential weaknesses of these objective symptoms or the field sobriety tests. But specifically, there's also a way to show that the machines themselves are not operating correctly. So as for the preliminary alcohol screening device, and the same for the breath test at the station, there's a number of ways that defense attorneys bring up in court to challenge these devices. One of them is that they're simply not accurate. The idea is that, let's say you are a 0.05 blood alcohol level. That is your actual blood alcohol level. And you blow into a machine that is not properly calibrated. It can give an incorrect result. It may report a 0.09 blood alcohol level. And so in California, and I'm sure many other places, under Title 17, there's a requirement that they calibrate these machines. Either, I think it's every 10 days or like 150 uses, something along those lines. So they're required to calibrate them quite often, or rather accuracy check them quite often. If they've gone for more than 10 days at a time or 150 uses without being accuracy checked or calibrated, that can be something that attorneys use in court to discuss why the results may be unreliable. In general, there's a jury instruction that if the machine, its maintenance, or its operation are not compliant with the California Title 17 requirements, then you can question the results of that machine. For example, another way that these tests can be challenged is if there's no 15-minute observation period from the time that the officer sees you to the time that you give a breath sample, then they are not being compliant with Title 17 because you can draw those results into doubt. And the reason for that is, as we discussed before, you may have acid reflux, you may have just vomited, you may have had an alcoholic drink in the interim 15 minutes. And if that's the case, then you can't be sure that mouth alcohol isn't providing a false reading in that breath test. So that's another requirement that California has, and I think other places follow suit. In addition to that, each test has to be done 2 minutes apart. There needs to be a certain volume of air that's blown into the machine. There's many, many things that criminal defense lawyers will try to look for to see if the tests are being done properly. And that's just the tip of the iceberg for the breath test. Another defense that a lot of attorneys will use in court, and it's quite interesting, is the rising blood alcohol defense. So essentially the way this defense goes is you go to a bar, you haven't had anything to drink, and let's say you just down 2 shots of whiskey. And then your friend's like, all right, we got to go to this next bar across town. And you're thinking, well, I just had 2 drinks, but I feel absolutely fine. And then you get in the car and you get pulled over. The officer smells alcohol, looks at your eyes, maybe hears something on your speech, and decides to begin a DUI investigation. You give a preliminary breath test, and the results are something like, let's say, 0.08. Then you go to the station and you give another breath test, and the results are like 0.10. So at trial, essentially, what will happen is the criminal defense attorney will likely hire an expert who is an expert in essentially how your body metabolizes alcohol. And what an expert oftentimes can effectively argue is that from the moment you took those drinks to the time of driving, your body was metabolizing the alcohol, and so your blood alcohol content was rising. When you got pulled over, you may have been somewhere at like a 0.07 or a 0.06, but from the time that you began the DUI investigation, which could sometimes take 20, 30 minutes, to when you gave the preliminary alcohol screening device, you were no longer driving, but your body was metabolizing that alcohol. And so when you gave the breath test at the station or at the field, it became 0.08. And then your body was still metabolizing that alcohol on the way to the station, which is shown by the fact that when you go to the station without having any drinks in the meantime, your blood alcohol level is now 0.10. So there's a blood alcohol curve that even the people and the prosecutors, experts will draw that shows the way that you somehow metabolize that alcohol. Sometimes criminal defense attorneys can secure acquittals by drawing doubt as to whether or not you ever had a 0.08 blood alcohol level while driving, or if that level was only achieved while you were outside the car being investigated. Now, of course, a lot of people don't like this defense because, the person is still drinking and driving, but the law is clear. Were you driving with a blood alcohol level of 0.08 or higher? Despite all the challenges that attorneys make, despite all the defenses they have and how charming, not myself obviously, but other criminal defense attorneys can be in the courtroom, if the evidence is there, the jury will convict. Jurors, for the most part, after being properly selected, really are able to sift through all of that and just see, is there enough evidence? And that's what it's all about. If someone is acquitted at a DUI trial, it's generally because the state of the evidence is just not good enough to convict a man of a crime. And that's really what we're dealing with. There needs to be proof beyond a reasonable doubt. And, I think that's one of the great things about America is that we require this great amount of proof before we take away someone's liberty.
The last topic I want to get into is the 0.08% blood alcohol content level. I think it used to differ between states, but now there's kind of a federal standard of 0.08%. What does that equate to? Is there a way to scientifically say 0.08 is 2 drinks, or say it's 2 drinks for a person of my size and weight? Or does it really just depend on the person?
It does depend on the person. It depends on their size. It depends on their weight. Sometimes male and female can differ. Sometimes certain individuals with different types of metabolism, whether or not they've had a full 8 hours of sleep, whether they've eaten, can affect how fast they reach 0.08 or how fast they reach any blood alcohol level. So it actually really does differ. There may be individuals that somewhere that can drive safely with 0.08, but because we are so serious about deterring, understandably so, drunk drivers, that we've set the limit, at least in California. I'm not sure with every other state. I know that there's some states with 0.05 maybe, but we've set the limit at 0.08 in California because we believe we're casting the widest net and leaving the safe drivers on the road.
Omid, thank you very much for taking the time to come on the show. It was great having you. A lot of very valuable information.
Absolutely. I was happy to be here, and I love your show. I'm an avid listener.
Hope you enjoyed that video. Remember, very important, don't ever drink and drive. It's just not worth it. Get a ride share, get a friend to take you, or even wake someone up, even if they're going to be mad at you. It's just not worth it. If you ever are charged with a DUI or DWI, please consider hiring an attorney licensed in your state who has experience with these types of cases. That would be your best bet. If you enjoyed this video, please subscribe to our YouTube channel, follow us on Facebook, Twitter, and Instagram, and of course on thelegalseagull.com, where you'll find tons of free resources. Until next time, stay legal.